Today we are discussing the criminal trial of Jennifer Occonell Nowain when it comes to her charges for disruption of a public meeting and delaying a peace officer and resisting arrest. After 2 days of trial and multiple days of deliberation, the jury came back this morning. They stated that they were deadlocked on charge 2 and that they had come to a decision on charge 1. The first charge is 403, which is disruption of a public meeting. On that charge, they found Jennifer Occonell Nowain guilty. On the charge 2 for resisting arrest and delaying a peace officer, they said that they were deadlocked with a count of 11-1. They did not differentiate what the count was for or in favor of. They did state that even with more time to deliberate or with more arguing from the attorneys, that they would not have that deadlock broken because they did not feel that the people had proven beyond a reasonable doubt. They were stuck on that beyond a reasonable doubt that she had resisted arrest or delayed the peace officer. So that charge was dismissed by the judge and deemed a mistrial on that charge. The people decided that they did not want to retry that case, so it was dismissed by the judge. On the count of 403, disrupting a meeting, they will hear sentencing on January 14th at 9 a.m. What I do want to break down is why this case is important and why an outcome in this case matters. We have a culture in that boardroom of people who misbehave and cause disruptions to the point where real business cannot be conducted. And this happens on a regular basis. Unfortunately, many of those incidences have been Miss Occonell Nowain or her husband, sometimes acting together. Because our district attorney chose not to file earlier charges that were brought against Miss Occonell Nowain when she disrupted a meeting and chose to sit down and then later lay down, resisting arrest, resisting leaving, shut down the meeting, and was actually carried out by sheriff's officers and then cited for her disruption. The charges were never filed by the district attorney. I was present at the presented court date or the posted court date, and I went to the court clerk and said, why was this date vacated? What happened? And they said charges were never filed by the district attorney, so the date was vacated and it was dismissed. So because that was never filed, never charged, and never prosecuted, none of that was admissible into this case. So her history of disrupting these meetings, even though documented through the citation, could not be presented unless she chose to take the stand and incriminate herself. She chose not to take the stand in this case, so none of that could be presented by the people. And so that in itself is a failure by our district attorney to act. Had they done that, had they pressed charges on that and saw it through, she would have had that experience also in that resisting of arrest where she had to be carried out of the room, would have all been admissible. And the jury would have seen that and seen that continued behavior. Instead, what they saw was the testimony of the detective who was the arresting officer, who said she was not angry, she was not rude, she was not cussing at him, she was not violent. She just refused to comply with orders multiple times, resisting arrest, refusing to comply, and multiple times refusing to leave the building, resulting in the decision to arrest her, and refusing to stand up to be arrested. So with that whole testimony and the way that the prosecutors presented the case, there was doubt in at least one juror's mind that it was beyond a reasonable doubt that she resisted the arrest or delayed the peace officer. So why does that matter? Well, some of that doubt could have been the actions and behaviors of the other people in the atrium or foyer of the meeting that were taking the duties of the other officers in that room over there to handle that situation. It could have been the media personnel that refused to leave the room and had to be physically put on the other side of the door that had the jury confused as to whether it was solely beyond a reasonable doubt her resisting the arrest and delaying him. So there are many factors that went into this. Again, had our district attorney filed the original charge when she was removed from the chambers just months before, we may have seen a different case. But why in the entirety does this matter? Because we cannot continue to conduct government business in a building where people don't want to attend. We have many members from our community that used to watch these meetings regularly who refuse to attend. They only watch the recaps. They only watch online where they can fast forward through the chaos, and they are not attending. The other problem is our media locally here and mainstream media sources are only reporting on the things that get clicks. So they are only reporting on the circuses that take place in this room, not the actual business. We now have an entire community that is upset because a facility for alternative custody is set to be put in next to their neighborhood. And that has been on agendas and in discussion for months, almost a year now. I think it's 8 months that it has been being discussed at both the Reading City Council and the Board of Supervisors. None of the media sources are putting an impact on actual business being conducted because they are focusing on the drama. I'm going to go back and try to find the videos and the agenda items of what happened during those first few meetings where they presented the 3 options for the placement of that facility. But I would almost wager a bet that something chaotic between one of these bad actors happened during that meeting that was reported out. Something divisive happened on the dais between supervisors that was reported out, rather than, hey, the alternative custody program is moving forward, and these are the 3 sites that were discussed and presented, because there was an entire presentation. And I know that I did a recap video on it, but all the media outlets have a duty to inform the public, and the public is not being informed. So now there's outrage, and there's more lawsuits that may be pending, and there's more fallout because we are a community that is being fed division, not a community that's being fed facts. So this being tried and being found guilty of disruption of a public meeting is hopefully a huge step in the right direction and a deterrent from the bad actors who like to come and try to cause disruptions in these meetings. I hope that as we go into this next year, we can see our media companies take responsibility for informing the public of what is going on in government business, and our people in our community doing a better job participating in a positive and professional manner at these meetings. I must take ownership. There have been times, even a couple weeks ago, where while nobody was speaking, while there was a break, I spoke across the aisle at somebody not helpful. That is one thing that I will commit to working on. I know that that feeds into that culture, and I need to do better. So I will take responsibility for that. I just hope some other members in the community will see this response from the jury and make better decisions so that we can move forward and have a productive governance of our county and move in the direction that Shasta County and the city of Reading deserve. Thank you so much for listening. There are so many other details, but none of them really worth getting into. And I always appreciate all of you for being involved, being engaged, and taking the time to get your information from Mountaintop Media. Thank you so much and have a wonderful day.